Thank you. Please be seated.
I don't need that.
Right? Well, good morning, everyone.
Good morning.
I'm Presiding Justice Gerald Whalen, and let me begin by saying how wonderful it is to be back here in Syracuse in the 5th JD in this magnificent courtroom, which harkens back to great memories of Judge Tormey, our former AJ. We are very pleased to be here. Let me introduce to you, before we get started, our panel members. To my right, we have Justice Nancy Smith from Rochester. To my left, Justice Donald Greenwood from Syracuse, who some of you may know. We have Justice Scott Del Conte from Oswego, also from the 5th, of course. And we have Justice Craig Hanna from Buffalo. We also have with us today in the audience other members of our court. So they're not on the clock sitting on a panel, but they wanted to come down to be part of this wonderful ceremony today and to celebrate Onondaga County Bar Association's anniversary. Justice Stephen Lindley from Rochester is here. Justice Tracy Bannister from Buffalo is here. Justice Mark Montour, also from Buffalo, is here. And Justice Henry Nowak from Buffalo is here. I'm not sure, we may have, and I'm going to announce them anyway, but they may not be in the courtroom. We have one at least. We have Justice Edward Carney, a former member of our court, a very distinguished former member of our court, who's here today. Thank you for being here, Ed. Justice John Sentra and Justice Brian DeJoseph, also 5th JD Syracuse folks that are proud alums of our court, but I'm not sure that they're here today. So welcome all. We're also here and especially honored to have with us this morning the Chief Judge of the Court of the State of New York, the Honorable Rowan Wilson. Judge Wilson, Chief Judge Wilson. I have had over the last now, is it a couple of years maybe, the privilege and honor of serving on the administrative board of the courts of the state of New York, and that puts me in proximity with Chief Judge Wilson because the administrative board is made up of the chief judge and the 4 PJs in the court, and so we work together on a lot of different important matters that need to be addressed by the court system, and I can tell you firsthand that the Chief Judge Wilson is uniquely suited for the role he currently occupies. He is an outstanding judge. He's brilliant, and when I say that, I don't use that word very often about fellow judges or lawyers, but it is true. He's brilliant, he's thoughtful, he's patient, especially with me when he needs to be sometimes. But can I tell you the characteristic that I think really shines through, and if you have time to say hello to him while he's here in town, you'll find it right away. He's incredibly kind. He's a kind person in his soul. And so we are honored and thank you, Chief, for being here and being with us. And his schedule is incredible. And so for taking the time out to be here today, thank you. We're also glad to be joined by the Deputy Administrative Judge of the courts outside of New York City, Syracuse's own favorite son, the Honorable James P. Murphy. Thank you, Judge. I'd like to publicly thank the 5th Judicial District Administrative Judge Deborah Carol Lunis and the 5th Judicial District Executive Don Dorr and Deputy District Executive, who I met in person for the first time today, Joelle Doherty. I believe Don and Joelle are in the back somewhere is what I'm being told. Oh, right here, right up front. Good. For their invaluable assistance in making the courtroom available, making the staff available, and greeting the court as warmly as you have. Thank you so much for doing that. Don Dorr is a former 2-year program person with the 4th Department, which means he started his career at the 4th Department And once you're with the Fourth Department, whether you like it or not, you're always a family member. And so, Don, thank you very much for being here and all your assistance. I understand there's a plaque, Don, that has been anonymously donated, right? And this plaque is going to commemorate our sit here today, and it's going to hang somewhere, we think, right outside the courthouse, courtroom. So, Don, thank you very much. And lastly, and I'm not even sure if she's in the courtroom, she may not be, but I'm going to be retiring in the next year or so, and this is an opportunity for me to publicly thank in this community Colleen Farrell. Oh, there she is. There she is. I see her. Colleen was in our 2-year program also, and she's, after being in the 2-year program, everybody saw how brilliant she was, and they grabbed her, and the judges would say, you know, we'd pick the best of the best out of our program, and the judges brought her in chambers, and she's been with us ever since. I want to recognize her not only for the great work she's done with the various judges, and currently with Judge Greenwood, but every time she's called upon to serve on a statewide committee, when we need to put somebody on there to represent the Fourth Department in a major endeavor, my mind always goes to Colleen. When I ask her, she always says yes. And Colleen, thank you so much. The court is sitting here today as part of the celebration of the Onondaga Bar Association's 150th anniversary, and so we all know that. The Onondaga County Bar has a great history of professionalism, collegiality, and service, and it's something to celebrate. In 1900, the OCBA had little more than 100 legal professionals and members, but now it includes over 1,500 attorneys, law students, and honorary members. And as the membership of the Bar Association has steadily increased, so has its impact on the Syracuse area and Syracuse community. Bar associations' leadership generally are elected by the members, and so they're accountable to the members. But they don't just look after their members. If you know the workings of bar associations, they're looking after not only the members, the lawyers, they're looking after the lawyers' clients. And they're looking after the reputation of the profession generally. They have, and they recognize this, an accountability to uphold the standards of professionalism. And that's been handed down to us. It's been handed down to all of us in the legal community from generations and generations of talented, gifted lawyers that have continuously taught the next generation how to behave as upright lawyers and citizens. This Bar Association has done that in a remarkable way for a century and a half. And that is something to be celebrated and to recognize. And so thank you very much. On behalf of the court, I would also like to congratulate the OCBA's current president, Sarah Rakis. Is Sarah here? Okay, she's getting ready for tonight, I think. President-elect Jimmy McCurdy and longtime executive director Jeffrey Unitas, and all of the members of the Bar Association for their efforts in preserving its lengthy tradition of excellence. Let's all, right now, give the Bar Association, Onondaga Bar Association, a round of applause for reaching this incredible milestone. We will now start today's calendar. So the first case on for argument today is case 880, People versus Washington.
Good morning, Your Honors.
Good morning, counsel. My understanding is that the appellant has submitted.
Yes, Your Honors. David Bassett for the People. Thanks for coming and saving me the drive on Rochester on this rainy day. I'm available and happy to answer any questions you might have about this case.
Okay, very good. No questions, counsel. Thank you.
Thank you.
Case 881, People versus Armstrong.
Good morning. May it please the court. It's nice to see the court in person as opposed to virtual. I'd like to briefly discuss the replacement counsel. Mr. Armstrong, after his plea, stated that he had mental health difficulties, he had difficulty reading and writing, and that defense counsel deceived him into pleading guilty. As a result, the trial court rightly assigned replacement counsel specifically for the purpose of the motion to withdraw the plea. No motion, however, was ever made. Instead, replacement counsel talked about the very, very, very good offer by the people and the stellar job of defense counsel. We would assert that under these circumstances, for meaningful representation to have occurred, that defense counsel should have either on the record indicated why a motion to withdraw was not made or make that motion to withdraw.
You understand the question, or the position? Let me ask you this. I want to hear about the confirmatory ID argument. Are you ready to address that this morning?
Yes, Your Honor. So in terms of the confirmatory ID argument, the record did not adequately reflect that Armstrong knew, that Beechner knew Armstrong very well.
Now let's drill down on that a little bit. But so typically what we have is, in the record, is some explanation of the number of times they were in contact, over what period of time they were in contact with each other. How close were they in proximity? Were they able to see each other? Did they have different types of environments that they saw each other in, right? And that would build the record to establish some kind of knowledge of each other. And in your argument here today, I think, is the record really wasn't developed along those lines. And it seems that the argument, your opponent's argument is, well, yes, because there was a kind of a declaration. Well, we look at him as, he looks at me like a big brother.
Right.
In other words, establishing not just knowledge of each other, but also like a quasi-familial relationship, which would mean some kind of long-term relationship. Are you saying that's not enough?
A claim by one party that they are like a brother is insufficient, we would assert, especially based on this record that's bereft of any support for that.
Can I ask a question, though? Is the defendant himself said he looks at me like a big brother, and the victim said that about the defendant, yes. And he's like a relative to me. He's like a brother, so it's both of them saying.
Again, though, in terms of what evidence was before the court based on the hearing, there wasn't that information of how many times did they see each other, where did they see each other, when did they see each other.
But, Counselor, isn't it true that the victim here identified the defendant by name well before he was presented with the photograph? He knew who the defendant was because he had been lured into the kidnapping by the defendant.
Still knowing that who the defendant was, again, doesn't reflect how many times they interacted, where they interacted, and the record, in our opinion, did not demonstrate that.
So knowing the defendant means he couldn't also identify him from a photograph.
In a confirmatory fashion.
Right.
That would be our assertion.
Very good.
Thank you, Your Honor.
Thank you, counsel.
Good morning, Your Honors, and welcome to our city. Elizabeth Dannon for the people.
The confirmatory ID issue, the record could have been developed more, right?
Your Honor, I would submit that during the hearing, when the record was being developed, there was exhibit, I believe it was 2, which was the defendant's interview with police, in which he acknowledged that the defendant had been found together with him at his residence, and that they had that the victim had been at the residence for several days prior. And the defendant also admitted that the victim looked to him as an older brother. And the defendant, when the police asked him why he thought he was here, it was like the Cody Beechner situation. There was obviously great familiarity. And Your Honors, as well, with the video evidence and the evidence of many other eyewitnesses, we would suggest that it's harmless error in any event.
When was the time period that took place, that evidence that you're referring to?
That the evidence, the time.
That he had been in the apartment, for example, was that before he showed him the photo, before the confirming ID, or was that after?
It was before, because the victim was found sitting together with the defendant at the defendant's residence, where he admitted he was residing at the time of the interview. I believe he later tried to distance himself and say he never resided there, but there was, he admitted that at the outset of the interview, and there's plenty of video evidence to support that.
We'll take a look at that, counsel. Anything further?
Your Honor, just with respect to the counsel's argument about the second counsel's effectiveness, we would submit that the legitimate explanation that the second counsel did not submit a motion to withdraw is that defendant abandoned the motion. His letters support that to the court. The second letters he wrote, and the date of those letters is the date of the original sentencing before second counsel had been appointed, so there's not an argument that second counsel pressured him into doing so. So thank you, Your Honors.
Thank you. Case 882, in the matter of Ashley Thompson, Christopher Thompson versus Snyder. Counsel, proceed.
Good morning. May it please the court, Thomas Babylon on behalf of Appellant Autumn Schneider. The first point I'd like to discuss this morning is that the family court lacked jurisdiction to hear this particular case. Family court is a court of limited jurisdiction, although it shares the same jurisdiction as the surrogates court in guardianship matters. That court's jurisdiction is also limited. Here,
But
yes.
if the family court, this couldn't have been heard by surrogates because family court already had the case.
That's correct. They share similar jurisdiction, but the point is that neither court had jurisdiction in this particular case, Your Honor. Jurisdiction in surrogates court or family court is defined by the facts outlined in the statute. The statutes that are relevant in this particular case require that the child have no guardian, that the child be in foster care with a permanency goal of guardianship, or that the parental rights have been terminated of the child's parents. None of those facts are in the record of this particular case, and because of that, the family court lacked jurisdiction. And because of that, this particular case should be reversed and the petition should be dismissed. The second point I want to discuss today is that the family court failed to make an inquiry into the child's relatives and failed to issue process or join relatives that it was required to. Here the record's clear that the grandmother at the time the petition was filed was living with the child.
But was not taking care of the child at all and didn't live with the child the whole time?
Well, that's correct.
The great-grandmother was.
At the time the petition was filed, though, Your Honor, the child lived with the grandmother. The evidence is that she cared very much for the child. That evidence is undisputed by all the parties. The statute requires that if the child lives with a particular person, that person be named in the petition. That was not done here. And the reason that's important is because that particular person now has no right to appeal this particular case. And she didn't have the rights that she would have under the particular case that she would have.
Mr. Babylon, though, but what about this Article 10 proceeding, the neglect proceeding that was brought on with the subject child? Doesn't that give the family court jurisdiction?
No, that particular Article 10 proceeding was dismissed, is ended, is terminated, Your Honor. When the guardianship, when the original guardianship took place, the Article 10 was terminated, Your Honor. There was no further supervision by the department. There was no involvement with the county other than that they would have to be noticed of a change in guardianship, which they were in this particular case. So the Article 10 proceeding does not give jurisdiction to the family court in this particular case because it had already been terminated. But the other point I want to discuss today is that here the family court failed to join the grandmother as a party, and they failed to do the necessary inquiry to determine who who this child's other relatives were. This is particularly concerning because none of the father's relatives were noticed with regards to this guardianship. And the surrogate's court is clear that it requires the court to make this inquiry into other relatives of the child prior to determine who should be issued process in this particular case and who should be notified of the guardianship case. That was not done here, and because of that, there could be countless numbers of unknown relatives that should have been noticed of this particular proceeding. Because of that, the lower court's order should be reversed. Additionally, the court failed to join the grandmother, who clearly should have been a party to this case under the statute. The third point I want to discuss today is that the petitioners failed to prove incapacity here. The testimony at trial was that the great-grandmother...
Great-grandmother herself testified that she was incapacitated, that she couldn't take care of these kids.
The great-grandmother testified that she was no longer to pick up the child because it got heavier, and also that she was unable to keep up with the child. But also what was testified to is that the Thompsons...
How old was the child, counsel?
I believe the child was 4 at the time, Your Honor.
4 years old, and how old was the great-grandmother?
I think 76.
Yeah, and she's indicating that she can't keep up with the child. If you can't keep up with a 4-year-old, are you able to take care of the 4-year-old?
Well, Your Honor, that's a very good question. Here, she had moved in with the Thompsons, and the Thompsons had been assisting her with care. Prior to that, she had lived with the grandmother who had been assisting with
So
care.
somebody else is taking care of the child?
Well, assisting her with taking care of the child, Your Honor. I think it's very concerning that the inability to pick up a child or the inability to keep up with a child would result in incapacity, because pretty much any parent or guardian with a minor disability would qualify as being incapacitated.
Might that be a different argument if the great-grandmother was in here arguing, I'm not incapacitated, I can keep up with this child, I can do this? We don't have that here. We have the great-grandmother saying, I can't do this anymore.
Well, that would be on consent, Your Honor, and this is part of my argument. And there are certain provisions where a guardian can consent. However, under the kinship guardianship program, that is not permissible. They have to prove that the current guardian is incapacitated. So that's how they proceeded today, and rather in the original case, and that's for that reason alone they are required to prove incapacity. There are other provisions. The guardian could have filed for a successor guardianship, which I think the court would have had jurisdiction to hear. In that case, she could have consented to there being another guardian. That did not take place here, though, Your Honor, and because of that, the lower court's decision should be reversed.
Any further, counsel?
Nothing further.
Thank you.
Good morning. Lisa Cuomo on behalf of the Onondaga County Department of Social Services. May it please the court, I would point out that this was a kinship guardianship order, and the individuals that the grandmother went to live with were named as the successor guardians. So I think
The Thompsons?
yeah, so I think that Mr. Babylon may be confused with a standby guardian, which would maybe require you to go to surrogate's court. But they had been, upon consent of the appellant, named as the successor guardian, not her mother, the grandmother, but the Thompsons. So when the great-grandmother became incapacitated at 76, her husband had died, she wasn't able to handle the child, then she moved in with the successor guardians, and then they took over. And as the court is aware, under the social services law and the kinship guardianship, that is completely permissible because you want to make sure that the child is continued to be taken care of during that time period until they have been put in place as the actual guardian. I would also note that the appellant in her own modification petition before the lower court alleged that the great-grandmother was incapacitated. So I find it incredible that here she would come and say that the grandmother was not incapacitated and the child should have maybe stayed with
Does it make a difference, though, if their argument is they didn't prove incapacitation and they have to prove that, and without that, they can't move forward, as opposed to taking a position as to whether or not she is or isn't incapacitated? Do you understand the difference?
No, I understand that,
Yeah.
but if you've, in your own petition, alleged that she's incapacitated,
But does it really even matter? Because isn't it a change of circumstances that we're really looking at? So the incapacitation at the end of the day, it doesn't really matter.
It's also the best interest of the child
Right,
as
both,
well.
yes.
You know, the combination of that. So clearly, if the grandmother says at 76, I can't do it, and moves in with the successor guardians, then that should be enough to meet the threshold for incapacitation. I would also note that when you talk about notice, this was a family court order, a kinship guardianship order from June of 2023, I believe. And that order, the appellant agreed or stipulated that the Thompsons would be the successor guardians. And so the notice was appropriate under those circumstances. The grandmother wasn't entitled to notice under this framework. In addition, the grandmother filed her own petition.
So that goes to the issue of failure to join necessary parties. You think
Correct.
based on that, that's not necessary?
It's not necessary, and all the
And
necessary
again,
parties
because
were
she
joined.
brought her own petition, she had all the notice she needed, and she
Right.
participated, so, yes.
So, and she did participate in the proceeding. So I would just indicate that clearly,
And she didn't register an objection to the proceeding going forward?
no, no. So under these circumstances, I would say that the family court obviously had jurisdiction. It was their own order. It was a kinship guardianship for a successor guardianship. And it was appropriate to transfer the guardianship to the successor guardians, the Thompsons.
Very good. Thank you, counsel.
Good morning, Rebecca Kantz on behalf of the successor guardians, the Thompsons. Everything's pretty much been covered. If there's any additional questions, I would just like to point out that one of the arguments about the grandmother was that she had been living there, and the great-grandmother, who was the guardian, had to evict her because she was afraid of the grandmother at that point. The grandmother has no income. She was going to file for Social Security, benefits and everything. The Thompsons are, they have income, they have a steady house. They moved here to get a relationship with the child when they knew that they were heading towards that. So they've done all the steps that they needed to. Family court, who heard the underlying matter, absolutely had subject matter jurisdiction. The Thompsons were listed as successor guardians, so the family court should be upheld.
Thank you, counsel.
Thank you.
Case 883 in the matter of Eric Brown versus Raputo.
Good morning.
Proceed, counsel.
May it please the court, I'm Casey Duffy on behalf of Mr. Brown. Just to be clear, Mr. Brown is only seeking visitation in the form of occasional letters and phone calls with his son. And at trial, there was no evidence whatsoever that communication in that form would be detrimental to the child or otherwise not in the child's best interest. Although there are allegations by Ms. Ruperto of domestic violence against her, there was no testimony or evidence.
While she was holding the child?
That is correct and unfortunate, certainly. But there was no testimony about the effect of that on the child after the fact, or that the child suffered any negative consequences as a result of calls that were held after that.
But can't family court surmise that from those facts, say that the child is in, it's a dangerous situation for the child, even for visitation, based on the father's act toward the mother with the child being right there?
I think in certain cases that would certainly be reasonable. Here, there was no indication that the child was the direct target of any violent act.
Counselor, the court saw it that way, that there was a detrimental effect, but also that the father had made no efforts to develop a relationship with the child. So those two things together were what supported the court's determination, correct?
Right. I mean, that kind of leads to my second point, that Ms. Ruperto's own testimony directly contradicted the finding that Mr. Brown had made no effort to foster a relationship with his child. I mean, there are many, many examples in her own testimony that indicate that Mr. Brown was seeking to be and was an active participant in the child's life before and after he was incarcerated. He drove her home from the hospital after the child was born.
Counsel, what is my recollection, correct me if I'm wrong, you know the record better than I do, certainly, but My understanding is that for about the first 11 months of the child's life, the father was living with the mother and the child?
He testified that she lived, or that he lived with the mother and child. She testified that he stayed there a lot, but
Didn't reside there, yeah. What do we have in the record to demonstrate that during that period of time, that he was engaged with the child in a close relationship? Do we have anything in the record that would demonstrate that? What he did to help care for the child?
He testified that he was very involved with the day-to-day care of the child. I mean, she acknowledged that he was certainly present a lot, but denied that he was involved with things like changing diapers and feeding and that kind of thing. But
wasn't she basically saying that it's a pretext to really be with mom more than the child? Isn't that what came out in the record?
she did say that in response to a question from the court directly.
Right. And our standard review here is sound and substantial basis by the family court judge.
But the focus needs to be whether or not the contact with the child would be detrimental to the child.
Right.
And really here, there's no indication that the child suffered any detriment from the calls and letters that they were exchanging before and during the temporary order by the referee.
Wasn't there a settlement in August of '23 where there was some agreement reached relative to the exchange of photographs, telephone calls, and that kind of thing?
There was, and at that time, Ms. Ruperto did indicate that she would be comfortable with that. It's also
Say that last part, I didn't hear that.
Ms. Ruperto indicated that she would be comfortable with occasional mail and phone calls. I think it's also important to note that she testified that she had a good relationship with Mr. Brown's father, and at no point did anybody ever suggest that maybe Mr. Brown's father could facilitate the contact. I know the court's main concern about the best interest of the child was the potential to expose the mother to future harm. But, I mean, there were certainly...
And the child, potentially, to future harm.
The only finding in her decision that relates to the best interest of the child was that it would not be in the best interest of the child to expose the mother to future abuse. So, I mean, that assumes a lot, that the mother would have any contact with the child, with Mr. Brown as a result of this limited communication. And also, if, that logic applies to this case, it would apply to every case involving allegations of domestic violence.
Anything further?
No, Your
Thank you, Counsel.
May it please the court, Andrew DiPasquale on behalf of Ms. Ruperto. I just want to start off by talking about that settlement conference that was in 2023. The trial took place quite a while after that. By the time that the trial arrived, both Ms. Ruperto's counsel and the AFC were asking for no contact in their opening statements and obviously held that position throughout the trial. So there were events that took place throughout that period that impacted their position. As far as the point about it, the contact being a pretext to speak with the mother, I think that was well established in the record. There was one exchange that was somewhat bizarre when they were talking about the amount of photos that the father was receiving. And through that discussion, it came out that he actually asked for like 3 or 4 times as many photos from the mother. And so, the court had a 17-page decision.
Just to clarify, as I read the record, and the point you're making is he was seeking photos of the mother, not necessarily photos from the mother that might be the child.
Correct.
Right? He was seeking photos of the mother, not necessarily the child.
Correct. Pictures with just the mother in them. Right? Then as far as the living situation, there was a lot of contradictory testimony throughout this record. But in that 2023 conference, the counsel for the father did indicate when he was asked directly, where was your client living with mom? Was she not? And he did not say that she was. He said that he had spent some time there, but there was no statement about him actually living there at that time. And then as far as, there was one instance in the decision where the term no effort came up, but the term no meaningful effort was actually what occurred more often, and I think that better captures what the court was thinking when it was talking about the father's efforts.
Counsel, before you sit down, I think the issue or your opponent was talking about none of the abuse was directed towards the child. Your position is vicarious trauma. It always happened when the child was present.
Exactly, and I believe that there was two total instances that involved my client, or the child, being in the presence of the domestic violence, and there was an additional incident that was testified to about my client's other child being involved. So, you know, you have 3 instances where children are present, and then you also have the 2 instances while the child, in this case, was in utero, where while mom was 3 months pregnant, father tased her, and at 8 months pregnant, there was abuse so bad that my client was in the hospital for a week, and that was I think 4 or 5 exhibits that showed the injuries there.
Any further, counsel?
No, Your Honor.
Thank you.
Thank you.
Case 884, in the matter of Burley versus Richmond.
Submitted.
Is it completely submitted?
Yeah.
Oh, okay. That's submitted. Thank you. Case 885, Hutchins versus Medstead, Krause Health Hospital, Inc.
The odds are even.
If everybody gets settled, thank you very much. Please, Mr. Strano,
John Sarando, on behalf of the appellant, this is an appeal from a decision in order dismissing the patient's action for medical malpractice against the doctor who delivered her child with a C-section. It's our position that the plaintiff's expert opinion was sufficient to create a question of fact in this matter, and the plaintiff had prior cesarean operations.
Counselor, can I interrupt you for just a minute here? Just to frame this argument, as I understand, you don't disagree that the defendant shifted the burden here?
No.
You don't disagree with that, and you don't disagree that there are certain theories, initial theories, that have been abandoned no doubt about that. So we're focused in pretty squarely on the issues around what the defendant physician should have done at the time the surgical site was closed, right? Okay.
Right, and it's our position that the report is sufficient to create a question of fact. The trial court indicated that the Passero case was similar to the Passero case, where the third department found that the doctor's affidavit, the expert's affidavit, was insufficient. In our case, we don't have a mistake. There was an indication that there was a deviation. There was sufficient information put forth as to what the doctor should have done. And I think it's surprising.
The trial court referred to other deviations in its long written decision. And your position is basically, but the deviation is well established by the expert, and they say it's conclusory. What do you say about that whole?
I think our expert was very specific on what the doctor should have done. The doctor should have been very concerned with the fact that there was a note from accompanying the patient when she was transferred to be careful of the adhesions because of the prior C-sections that she had. There was also an indication, it was funny, in the EBT, the deposition, you're asking the doctor, well, this isn't, she said she did this. And the question then, well, that wasn't in your operative note, operation note. And she said, but I still did it. She's almost creating a question of fact herself by indicating, well, it's not in there, but I did it. It's not in there, but I did it. I mean, her failure to determine whether or not the omentum was properly cauterized before she closed the patient.
Mr. Randall, that's really, your main argument is, look, the experts are divided on that. There's two different opinions from two different experts, and isn't that something that should be properly submitted to the jury for consideration?
Yes, Your Honor. They took out 2,500 milliliters of blood in that second operation that was 5 hours later. The only way, it's almost like res ipsa loquitur. The defendant opened the lady up, and she didn't close the lady up properly.
I think we understand that argument.
I think, yes, and the other thing is, as far as the hospital is concerned, I think the plaintiff had a right to expect a satisfactory treatment from the hospital, that she was paying for the services that she got, and we would rely on her brief for everything else.
We'll take a look at that argument.
Thank you.
Counsel.
Good morning, Your Honors. May it please the Court, I'm here on behalf of Dr. Mestad. We ask this Court to affirm the order granting her motion for summary judgment.
So your argument is, if we could frame it, getting to Mr. Serrano's argument, the battle of the experts, you're saying, yes, there is a battle of the experts in this regard. If you read the plaintiff's expert, they do challenge the process and how it happened, but your argument is it's conclusory, right, and even speculative, I think. And so explain, if you will, why the language in the report, which is somewhat detailed, is conclusory. Why should we find that?
It's conclusory, Your Honors, and speculative, because this Court's precedent is well-established and axiomatic, that a plaintiff cannot raise a triable issue of fact in a medical malpractice or really any case by blatantly ignoring the proof in the record. And here, the proof in the record that they ignored was Dr. Mestad's deposition testimony. And I'd refer this Court to page 2292 of the record on appeal. That's where motion counsel, not appellate counsel, stated that their expert took the operative note at its face, not essentially what Dr. Mestad testified to at her deposition.
Counsel, let's see if we can break this down for a minute, because there isn't any dispute whether or not the plaintiff's response is speculative or conclusory on a lot of different theories in the case. We're really down to one theory, and the theory is, should Dr. Mestad had looked beyond the surgical field? Do you agree with that?
I don't, Your Honor, because
You agree that's the plaintiff's contention on appeal?
I believe that the plaintiff's contention is that Dr. Mestad deviated from the standard of care by not checking the omentum before she closed.
Right. And Dr. Mestad even says in her deposition, we don't know if the plaintiff was bleeding at the time I closed or the bleeding occurred after.
And I believe that question, Your Honor, presupposes, respectfully incorrectly, that the bleeding was coming from the part of the omentum that Dr. Mestad had to go through to access the uterus.
Right, and that's where I'm struggling here, because as I read the plaintiff's expert's response, the expert says, when the doctor starts the surgery, there's a different set of conditions here, including there's a baby. And when the baby is delivered and removed, the omentum may shift and move, and that doctor has an obligation, if the omentum is moved from if it's now retracted or moved outside of the surgical field, you got to double check that. You can't just close up the surgical incision without making that inspection. That's how I read the plaintiff's expert affidavit.
Respectfully, Your Honor, I don't believe that there's any basis in the plaintiff's expert affidavit for that conclusion. The plaintiff's expert's opinion is essentially Dr. Mestad didn't state in the operative note that she inspected the omentum, therefore we can surmise that she didn't. The incision to delivery time period was only 4 minutes. So therefore, it suggests that in that subsequent 30 minutes, okay, after the baby came out, that she didn't check the omentum. I mean, that's basically.
Well, she did some other things during the surgery, too. I mean, there's some other things that happened.
These are just two blatantly speculative theories that have no proof in the medical record, and are blatantly contradicted by the proof that we do have. And back to the location of the bleed, I think one of the most critical points in this entire case, which the plaintiff's expert never once addressed, was the fact that when the OBGYN team opened the plaintiff back up, they reopened the incision that Dr. Mestad had made, they found no active source of bleeding at all. It wasn't until the general surgeon came in and made a vertical midline incision that she was actually able to find the source of the bleeding. And it's well-established law from this court that a plaintiff can't raise a triable issue of fact unless they actually address the opinions that the defense expert proffers. That's the
See, I think, I'm sorry, but I think that's part of where there may be some questions here is because your doctor testifies in the deposition at 2039 that Dr. Zamani doesn't indicate where the bleeding came from. And maybe it even occurred, as your doctor says, from the adhesion that I worked on.
Well, I don't believe that Dr. Mestad testified to the second part of that, Your Honor, but they reopened and looked at the exact same surgical field that Dr. Mestad had looked at, and there was no active source of bleeding. And setting the medicine aside, the plaintiff's expert can't raise a question of fact unless they address that opinion. And this court has held that in multiple cases. Wicks, Campbell, Keller, Van Bertel. I mean, a plaintiff's expert has to do more than simply say, well, I'm going to disregard the deposition testimony where she was asked detailed questions about every single thing that she did, and she offered detailed testimony. I'm going to ignore that and just assume that because one word wasn't mentioned in the operative report, she never looked at it. When she testified, it was in her operative field. She visually inspected the entire operative field. That included the omentum, and there was no active source of bleeding. And also, you know, the blood loss for this surgery, it was 600 milliliters, you know, and that's another fact that the plaintiff doesn't address in their expert affidavit.
Well, she said that she visualized what she could see. She didn't say, and I guess that's what you're referring to as the visual field, but she didn't see the whole omentum. So, and that's the plaintiff's issue, is that there was bleeding there, and the plaintiff's expert pointed out that there was other things she should have done.
Well,
And that raised the issue of fact.
It doesn't, Your Honor. The omentum is a large apron of fatty tissue that essentially extends from the stomach down to the intestines. The critical part of the omentum in this case, according to the plaintiff, is the part of the omentum that she went through in order to access the uterus. And Dr. Mestad testified, based on her memory of the surgery, her operative note, and 20 years as an operating obstetrician, that that portion of the omentum was in the visual field, was in the operative field that she visualized before she closed, and there was no active bleeding. For the plaintiff's expert to disregard that renders the entire expert affidavit conclusory and speculative.
We'll take a look at that, counsel. Thank you.
May it please the court, Matt Walsh on behalf of the defendant respondent, Crouse Hospital. There are three brief points that I want to address from the hospital's perspective. First, I just want to second and reiterate everything that co-defense counsel for Dr. Mestad has argued here. And to avoid repetition, I won't address any of those arguments further, but I would note that because Crouse is simply in this case for the alleged vicarious liability of Dr. Mestad, if this court upholds the trial court's decision in order with respect to Dr. Mestad, Crouse must also be dismissed from the case. My second point that I want to address is that plaintiff has abandoned any and all claims against the hospital in this case. The hospital submitted evidence and argued both at the trial court level and now on appeal that the hospital can't be held vicariously liable for Dr. Mestad's actions.
Counsel, the court didn't rule on that issue.
The trial court did not, well, they didn't need to rule on the issue.
Right, so that's, I mean, the plaintiff didn't lose on that ground at the court, did the plaintiff? No.
Well, so the trial court didn't explicitly.
It didn't reach it, didn't have to, found those issues academic or moot.
That's correct, Your Honor. But now on appeal, the appellant has failed to even address the arguments in their appellant brief that we raise. And there's ample case law about this issue from this court that if an appellant or any party at the appeal level fails to raise an issue in their brief, that issue is deemed abandoned. And even in oral arguments today, there was no mention of vicarious liability or the arguments with respect to that. So I would submit that all arguments with respect to the hospital have been abandoned. And the third point that I want to address is, even should this court entertain any arguments with respect to the alleged vicarious liability of the hospital, Krause is still entitled to dismissal. And put simply, Dr. Mustad is not an employee of Krause. She's a private attending physician with privileges to practice at the hospital. The record is clear in that regard. And generally, as Your Honors are well aware, a hospital can't be held liable for a private attending physician. Now, there are, of course, exceptions to the rule, but none of those are applicable here, particularly a theory of apparent agency. This theory can only exist where the hospital engaged in some sort of conduct that held out the provider to the patient as an employee of the hospital. And the record is simply devoid of any evidence that Krause engaged in any such conduct. And there's also no evidence that the patient in this case, Ms. Hutchins, believed Dr. Mustad was an employee of the hospital. In fact, she was employed by the perinatal center, where the patient received received a good portion of her prenatal treatment. And it was the physicians at the perinatal center who told her on multiple occasions prior to her eventual delivery that we're establishing a plan to deliver you at Krause. They told her of this plan multiple times. And there's ample case law on this issue that when there's an elective procedure performed by private physicians at a hospital, the hospital can't be held liable under those circumstances. And that's ultimately what this was. This was a planned procedure by her private physicians, performed by her private physician. And there's no evidence that the patient came to Krause based on any misrepresentation of the hospital. So I would submit that not only has the appellant abandoned these allegations against the hospital, even should the court entertain these, the hospital must still be dismissed as there's no basis for imposing vicarious liability. Otherwise, we rest on our papers.
Very good. Thank you, counsel.
Thank you, counsel.
Case 886, Morse versus Morse. Counsel, proceed.
Good morning.
Do you want to address the argument relative to mootness?
Sure, I will address that briefly. I've only read the transcript, as have you. I was not the attorney at the underlying proceeding, but it appears pretty clear on the record that withdrawal of the appeals was part of the discussion as far as the settlement agreement, which has not yet been memorialized in a written order, which my understanding is it's going to be at some point when one of the attorneys returns from a vacation or something to that effect. So I believe it's already been agreed to, but again, not written down. I wasn't there, but that's what I would say.
Very good. Thank you. Proceed.
So to that point, first of all, thank you all for coming today and shortening my commute. I appreciate that. I represent respondent Julie Morse, and as you're aware, this involves an appeal of grant of sole legal and physical custody of the party's marital children and setting a court-mandated visitation schedule. And as we just talked about, we believe that's been mooted or withdrawn based on the transcript that was provided to the court last week, I believe it was. But that being said, I'll keep this very brief. I primarily will rest on my papers, other than to say, just to remind and reiterate the standard that it's should not be overturned. The trial court decision on visitation and custody should not be overturned unless it's there's no basis in the record. As long as there's a substantial and sound basis in the record, that should be upheld. And I think here there's ample support in the record. It's 27 volumes. The court held 10 days of trial, several hearings before that. Frankly, the court could have probably found any decision they wanted to, and there would have been ample support in the record for that decision.
51,000 emails?
Yeah, it's a long record, and so I would just say, given that the court made a very well-reasoned decision, explained that decision, and justified it with citations to the proceedings, that it should not be disturbed, and I would just rest on that point, but would be happy to entertain any questions if the panel has any.
No questions, counsel?
All right, thank you for your time.
Good morning. Catherine Sullivan, attorney for the children in this matter. Briefly on the mootness issue, I would reiterate without restating what Mr. Powers said, but I would also point out that the court's transcript specifically states that with respect to custody matters, the agreement moots those matters, and this case is all about custody matters. The court also specifically said that she didn't have the power to deal with the attorney's fee issue, and that would not be moot. So it's our position that this appeal is moot and should be dismissed as such. If you don't find that it's moot, certainly the record is sufficient to support the Supreme Court judge's decision with respect to custody. The appellant's attorney, in her affirmation to the court, conceded that all but the legal custody issue was indeed resolved in that recent family court case setting, but the joint or the legal custody issue was not. On legal custody, I cannot think of a case that it would be less appropriate to have joint legal custody. Dad isn't seeking sole legal custody. Joint legal custody is just simply not appropriate in this case, and the court's decision is supported by the substantial evidence in the record. Lastly, the children. The children are doing well. They are now in middle school. That's opened up a whole new bunch of friends and classmates. LM in particular was, she's never really happy, but somewhat happy to report that she had a whole new host of friends that were kind of more in line with her personality and her interests. One might say she's finding her people, which is really nice to see. And they're doing well in school and in their activities. I would say that this ongoing litigation, these appeals, is not doing anything to help their relationship with their father. It's not improving that relationship, and I would say it's probably having the opposite impact, quite frankly. Beyond that, I'll rest on my brief unless you have any questions.
Thank you, counsel.
Thank you.
Case 887, Dacko versus Philadais.
Good morning, Your Honors. Sorry, Judge. Good morning, Your Honors. May it please the court. My name is David Hercola. I'm an attorney with the Serial Law Offices here representing the appellant defendant, Irakli Kaladze. I'm going to rely primarily on my brief. However, I would say that the issue involved here is relatively straightforward. There was an oral contract for the acquisition of property. The record reflects that there was partial performance on behalf of my client, who even the defendant admitted paid him at least $13,000. There's conflicting testimony from my client, or from, the appellant and the respondent regarding whether additional monies were paid. In the record, there is testimony supporting improvements to the premises that my client made, or the appellant made to the property, as well as the important fact that the appellant was in possession of the property from approximately 2019 until the Supreme Court signed the order effectively ejecting him from the property.
Yeah, Counselor, I think, as I read the court's decision and order here, the court says that essentially there's some dispute about what the agreement was, but there's no doubt that your client didn't meet whatever agreement was out there. And, but let me just finish this question, though. So there may be a breach of contract action in here somewhere, but your client's right to possession. Where does your client's right to possession arise here, where he apparently hasn't paid the rent, he hasn't fulfilled the oral agreement, and yet he's still living in the plaintiff's house?
So, Your Honor, he, first of all, was a vendee in possession under an oral contract by agreement of the parties.
Understand that.
Partial performance.
Understand that, but the right to possession, you don't necessarily get the right to possess when you enter into a contract to purchase property.
Not every time.
Not every time. So he did occupy the property, and he took possession of the property. And then there's some question about whether or not he complied with it, but that's where I think the court was having an issue here, is where does the right to possess originate from?
The right to possess, and I believe, Judge, based on the record and the testimony of the parties, comes from the fact, and maybe I'm misunderstanding your question, so please tell me if I am.
Right.
He took possession of the property pursuant to the agreement of the parties.
To purchase the property.
To purchase the property, he paid at least, undisputed, at least $13,000 towards the $40,000 purchase price. And over the course of time, there is a dispute because his testimony is that he paid $32,000 of the $40,000 to buy the house. Some of the factual disputes center around whether those payments were made or how they were applied.
I guess to be clear, I didn't see in the record where your client was demanding a closing.
Judge, I believe that there is an indication in the record, as well as the deposition testimonies, that he was ready, willing, and able to close.
He was ready and able to close.
Yeah.
Yeah.
So before the court rendered its decision, that had been conveyed, that he was ready to close. These two individuals knew each other. I mean, they weren't complete strangers that happened to meet.
They were friends.
They were friends.
Yeah, it's not that they just knew each other, they were friends.
They were friends.
Yeah, and their significant others were close, right?
Correct.
Yeah, and so, in looking at what happened here, it seems that there's some agreement as to what happened, but then disagreement. And part of the disagreement has to do, I think, with how was the money that was paid, even though there's dispute as to how much, how was the money that was paid going to be applied? In other words, was it taken and applied as rent? Was it a payment towards the mortgage, the purchase price, we'll call it, on the house? Or was it paid for taxes that came due while they were living there, but not as applied to the purchase price? Those questions all seem to be in dispute, correct?
I believe they are, Judge, which in part is a focus of the argument that we're making, which is material issues of fact did exist. The fact that the record itself didn't dispense with those types of questions when there is an agreement by both sides that there was an oral contract to purchase the property and that there was partial payment on that, and that...
Can we keep talking about partial payment? There's no record of an agreement because it's oral, right? And there's no record of payments because it's cash? Is that what?
There's an acknowledgement by the plaintiff.
We have
that there
oral
was-
contracts, we have cash. Is he living there still?
No.
Okay, so-
No, the court
Well,
rejected.
once in a while, people don't pay attention to courts. It's rare.
I know it's very rare, Judge, very rare.
All right.
Never on any of your decisions.
Yeah, no, thank you.
So
No.
there's questions of fact all over the place there.
That is essentially our argument, that summary judgment was not an appropriate remedy in this circumstance, given the questions that existed, the dispute and testimony. Quite frankly, I think based upon the tenor of the arguments that were made by plaintiff's counsel and the responses that we've put in over time on this case, you had huge issues of credibility, really, that again, should go to a trier of fact. Who's telling the truth? We have disputed stories here, but we do have enough essential facts to say that the parties reached an oral agreement, that there was partial performance, there's an acknowledgement on behalf of the plaintiff of receipt of partial payment, and there was no dispute that he was in possession. So which all go to exceptions to the statute of frauds, which I would just note in closing should be used as a shield, not a sword. And unless there's any questions, I rest.
No further questions, counsel. Thank you.
Thank you very much.
Good morning. May it please the court. Karen Felter from the Smith-Sovic office for the plaintiff Ryan Dacko. I'm going to be very brief. I think the questions of fact that counsel referred to are frankly questions that were only raised and muddled through inconsistent testimony of the defendant himself. The undisputed fact in this case, which he frankly acknowledges, is that there was an agreement to purchase the property. The agreement was supposed to be for a year. The defendant was supposed to pay $600 a month in
But
rent.
I'm not sure that that's uncontested. I thought it was 4 years. Was it 4 or 3 years, the 40,000?
Well, the defendant doesn't know when the agreement started. He's given all kinds of testimony. He said it started in 2019, then he said it was 2020, then he went back and said it was 2019. He doesn't seem to know when the agreement started. He doesn't know the date. He doesn't know the payments that he made. He doesn't have any record of them. He doesn't know when he made them or how he made them.
Everything was in cash, correct?
Yes.
Pursuant to an agreement between the two.
Oh, absolutely. There's no question that.
So how can you say, I guess when I'm struggling with this, it just seems to me there's just so many questions of fact here. Even your client has agreed to some of what he says and vice versa. We don't really know exactly what happened here.
Well, what we know is that this gentleman made no payments whatsoever on this property for the first 18 months that he lived there. And then
We don't know that for sure because he says he did.
He says that he made monthly payments, but he doesn't, he agreed that he made monthly payments, but he doesn't know how much they were for. He denies that they were rent, but it doesn't.
Well, even some monthly payments, even if there are some, it's partial performance, is it not?
Well, he said he agreed to monthly payments, but he never said that he made monthly payments.
But didn't your client acknowledge that he got some payments?
Oh, he did. He got $8,000, 18 months after the defendant moved into the property. And the defendant acknowledged that that money was money that he borrowed from his girlfriend. And then he received an additional payment almost a year and a half after that. So for 3 years, he lived in the house and paid a total of $13,000. And that is what is acknowledged by the parties. And the fact of the matter is that there was no partial performance of the agreement as it was made between these parties to perform within a year. There was no payments made or received. And the improvements that were made to the house, the so-called improvements that were made to the house, were wiring. And in the record, on page...
I believe a closet was taken out instead.
Well, it was a wall, an entire wall.
There was a dispute about that as well.
Well, there's no dispute about the fact that he took a wall down to make a 3-bedroom house a 2-bedroom house without authorization. He just took the wall down. And when he did, that released an army of mice in the house that chewed up electrical wiring and that sort of thing. And that is on the record in page 316 to 326.
Well, I believe that he testified that the reason he took down, whether it was the wall or the closet or whatever, was because it was infested with mice.
Yeah, but he did not discuss any of that with my client. He acknowledges that none of that was discussed, so to the extent that he took down a wall or a closet, it was not authorized work, and the release of the mice was the result of it. So we have a situation where, this gentleman meets him. They're not, just to correct the record, they were not actually friends. They met through the Ukrainian community through a mutual friend, and he was in need of a place to live. And Mr. Dacko, you know, understood his circumstances, felt bad for him and his wife, and or his girlfriend, and agreed to let them live in the property, make payments, and make a lump payment of, or at least attempts towards that. However, he wanted to break that up, of $40,000 over the course of a year. And none of that occurred. He never made any payments. He can't prove that he made any payments. The partial performance affirmative defense that he raised in response to the motion for summary judgment was his burden to prove partial performance. He has no record of any payments. He doesn't know how much the payments were. He doesn't know how he made them. He doesn't have proof of any income. He cannot state when they were made, how they were made. I mean, there's no evidence in support. He failed to meet his prima facie burden in terms of establishing that there were questions of fact on this affirmative defense. And furthermore, in this court's case in Cristo, I believe it was cited in our brief, this court found that if the agreement or the evidence is consistent, equally consistent with an agreement for rent, which is what this was, that the partial performance doctrine does not apply. So in that case, the plaintiff claimed that, you know, he was making payments on a mortgage and paying taxes, but the court found that notwithstanding that evidence, it was equally consistent with a landlord-tenant situation. And when that plaintiff failed to keep making payments in accordance with the agreement, he was subject to eviction. And the partial performance doctrine did not apply. And I think that this is the exact fact circumstance that is noted by this court in the Cristo case.
We'll take a look at that, counsel. Thank you.
Thank you.
Thank you, Your Honor.
Case 888, Fish versus City of New York.
Thank you very much. It's nice to be greeted with a smile. This is my honor, and I'm sorry that I'm turning my back to the other honors here. Thank you very much. I'm very honored to be here. I have fond memories of this historical site myself. I was the first Consumer Affairs Director for the City of Syracuse in 1972. So I don't know, I'm half the age of Honorable Murphy, but anyway, I'm still here and I'm surviving, which is kind of important. May I please the court, on behalf of my family, which is the reason I'm here, and my two sons, who have compassionately and generously looked at, provided for me as a survivor of a 2006 assault victim. 2006, and I'll give you some background. In the year 2006, June 21st was my happiest day of my life. I just completed a contractual agreement for about $100 million in value to form a company that was going to be global in nature. Secondly, six weeks later, on June 27th, I was drugged, assaulted, and violently threatened my life. I'm not using the word rape because it's very personal. This is the first time I have disclosed this in almost 20 years, incidentally. So I've had this in silence for over 20 years. My name is, of course, Gene Fish. I'm an 83-year-old, lifelong resident, central of New York, a Catholic, which is significant in this case, a heterosexual male, another significant, and a pro se, fee-waived litigant. I've spent decades contributing to the Onondaga community. I've been an author, entrepreneur, and I've done other things that at half my age, Honorable Murphy would probably may remember. But anyway, on June 20, just 6 days later, on 27th, I mentioned, in June, I was drugged and raped. The proximity of these two events are not coincidental. It speaks to the vulnerability I faced in silence that followed and the institutional failure to protect me. My two sons, my extended family, and close associates connected to my international enterprise have suffered deeply and have been irreparably damaged. Institutional defendants, New York City, the NYPD, and the District Attorney of New York, Robert Morgenthau, failed to investigate or act on my assault and on the fraudulently induced based contractual agreement that followed. Their inaction was passive. It obstructed justice and compounded the trauma I endured that I failure to delay my ability to seek redress and deepening the harm. This is why the Adult Survivors Act, Civil Procedure or Practice, Law Rule 2014J is fully intended to fulfill passive arrangements and latent injuries. Now, I respectfully ask the court to consider not only the statutes at issue, but the spirit in which were enacted. The Adult Survivors Act, 2014J, designed to remove barriers, not reinforce them. It was created to give survivors, excuse me, I might ask for some water if you don't mind. I've been sort of waiting long for this matter. Thank you very much. Now with the court's permission, I will turn to the legal basis of my appeal. Thank you so much, sir. I respectfully oppose the venue transfer that New York City moved the case from Onondaga County to New York City County, or New York County. Justice was in violation of Civil Procedure Law, Rule Section 510.03, paragraph, and Section CPL 503, section I think I'll stand alone on that one. All right. But anyway, and then justice proceeded to place several laws of New York State. The revival statutes are not textual puzzles. They are declarations and public intent crafted to serve justice. Venue transfers that impose logistical, economic, and psychological hardships run counter to both law and equality and equity. Point 3, trial court error and legislative intent. The trial court failed to consider compelling equities and legislative intent behind CPL, or Civil Procedure Law 2014, paragraph J. This was not a minor error. It undermined the central purpose of the law. It was not I respectfully urge the court to reverse the lower court's decision and restore the civil matter to Onondaga County, Supreme Court, 1st District. Point 3, the legislative purpose of Civil Procedure 2014, Section J, Subdivision J, it was updated in 2023 to eliminate barriers that historically silenced survivors, requiring a pro se like myself, elderly survivor like myself, to litigate in a distance, congested courthouse, with due respect, imposes to New York, imposes exactly the harmful effects of our CPL, Adult Survivors Act, seeks to prevent. This appeal seeks statutory harmony, not conflict. Messenger versus Festa, venue statutes must not be applied mechanically where injustice may result. Doe versus Doe, survivor plaintiffs retain forum protection. Bauer versus Weissman, venue determinations must balance procedural equities and parity burdens. Point 4, harmonizing civil procedure law review 504, section 504, paragraph 3, with CPLR 214J, 503, and 510.3. The Adult Survivors Act harmonizes a remedial statute. Its interpretation must favor survivors' access. Defendants misapplied CPLR 504.3 as the overriding, but CPL 503 and 510 remain operative. I think I made a mistake on that one, sir. It's 504, CPL 504 is the New York City entity applied to the law that they used. Legislative harmony and not mechanical displacement is the guiding principle. Courts retain discretion to deny venue transfer where it would result in significant hardship and inequity. Point 5, burden of proof under Civil Procedure 510, Section 510, paragraph subdivision 3. The burden rests squarely on the defendants. They must prove by Bryan standards, names and addresses, of material witnesses, a summary of their expected testimony, a confirmation of their willingness to testify, a clear demonstration of inconvenience without transfer. The city has provided none of this. No affidavits, no witness, no specifics, and generalized assertions. This is not enough. The law demands more, and justice requires it. Point 6, practical and constitutional barriers. At age 3, I hate to admit this, but at age 83, I face significant health and mobility challenges. Travel to Manhattan would disrupt essential medical care, impose physical care risk, and create financial hardships. Civil Procedure 2014J, under the Adult Survivors Act, protects the plaintiff's meaningful participation. The Fourth Department has already recognized my hardship by granting fee waiver status. As the sole fact witness and pro se litigant, my hardships are acute, not speculative. Equity aids the vigilant, not those who slumber. I have come forward under the law designed to give survivors like me a voice.
Sir,
I have not slumbered.
Sir?
Yes, sir?
You should begin to wrap up.
Okay.
Your time's near an end.
Well, then in that case, what I'll do is I'll get into my principal arguments already have mentioned, I think, but I'll mention a couple more.
Okay.
I think that one of the big issues that the defense submitted to Judge Antonacci outside harmonizing the 510.3 rule as well as the 503 was that they appealed that it was not renewable based on the order that was installed February 22nd, 2024. There was follow-up orders of February 16th, 2024, 25 rather, that I have appealed on. So we had a series of orders that were discussed during this whole period of a year and a half. The final order, and what I'm saying is the Civil Procedure 501 allows for to appeal the case based on the order that was received. So under that law, it gives every opportunity for me to submit it. And I'm sorry to say that the defendants have raised that because under the Adult Survivors Act, you're supposed to get priority as far as trial, as far as submissions, and other priorities. And then under the appeal law, CPL 5513, which gives you every right to appeal the case. So I have the opportunity, and it was sort of, I don't know what happened, but the result was that the judge did not rule in my favor after almost a year and a half of submissions of of arguments, and including the arguments that were presented by the defendants.
In that record, sir.
Pardon me, sir?
The record and your arguments are before us, so we'll take a hard look at those. Do you want to wrap up, please?
Okay, I'm requesting, Your Honor, that you reverse the order, place the venue back in Syracuse, New York, Onondaga County, and I think it's profoundly important that we do this as a venue case based on a civil rights issue as well. I think I was discriminated.
We'll take a look at that in your
Thank you.
argument. Thank you, sir.
You're welcome.
Case 889 in the matter of Boak versus New York State Department of Motor Vehicles. Okay. Normally appellant goes first?
Yeah, I am appellant.
Oh.
See which one we're supposed to be on.
Very good, thank you. All right. We get thrown easy up here. You're in the wrong seats. All right. Very good. Please proceed, counsel.
Yes. Good morning, Your Honors. Rachel Raimondi for DMV. Supreme Court's annulment of the DMV's determination was based on a flawed interpretation of VTL 1212 and must be reversed. Supreme Court looked at the facts or the moments just prior to the collision.
In the report, I think it was it a state investigator's report, indicated that the vehicle, petitioner's vehicle, was extending out into the roadway, right?
Yes.
Some over 5 feet, I believe, into the driving lane, and the four-way flashers were likely off at the time, right?
Yes, all
Okay.
correct.
Yeah, and those were obviously important facts for the DMV ALJ to be determining whether or not they were operating in a safe way and are somewhat at fault for the happening of the accident.
The tow truck driver, Book.
Yeah.
Yes, absolutely. Those are just, but some of the factors. The ALJ also considered that it had just stopped snowing, the roadway was wet, that it was dark, there's no artificial lighting on State Route 8. And the amber hazard bar, which would have been above the cab of the tow truck, was obstructed by the truck that it had on its flatbed. But Supreme Court applied the...
Which struck me, frankly, it's maybe doesn't mean a whole lot, but if you've got the amber lights on your truck for purposes of notifying people, but if you put something on the truck, you can't see the lights, that seems like a bit of a design issue, doesn't it?
Sure, but I think, it depends on how big of a truck you're loading. And in this instance, this tow truck driver was was transporting a truck that blocked the lights. And Padilla, the other driver, was unable to see the tow truck, which, as you said, was more than 5 feet into the driving lane, until it was tragically too late. Supreme Court believed that there were no cases about cars being stopped and VTL 1212 applying. And I just want to point the court to People versus Moran, which I cited in my brief. And that's about a car that was stopped in the driving lane on Taconic Parkway. And that driver was found guilty of VTL 1212. That, of course, makes sense with the running or operation. I just want to point the court to, there are two ways to look at this. You can look at the facts just prior to the collision, that he's in the car, he's in the middle of transporting the tow truck, the tow truck is, he's in the middle of using it to drop off the other truck.
Well, he had actually left it in that condition. I don't believe it was moved once it was stopped. He left it in the condition of being out in the driving portion of the lane, went in because there was a difficulty in accessing the driveway, is my understanding.
Mm-hmm.
It was blocked, and came out and actually was able to get into the tow truck maybe instantly before, or moments before the accident occurred, right?
That's right. So you can look at the use of the vehicle at that point, right before the collision occurred, but also you could look at it from before he got out of the car. It was reckless to be pulling over, slowing down on Taconic, and getting his tow truck into that position. There are two ways that you could look at this. And I just want to touch on defenses that Book is raising here, none of which exempt him from responsibility under VTL 1212. First, he's arguing that because he was operating a tow truck, he is a hazard vehicle exempt from the VTL. He's relying on VTL 1103B, and first of all, none of this is preserved. He didn't bring this up at the administrative hearing or during his administrative appeal, but VTL 1103B actually deals with state vehicles, which he is not. And in any event, that provision expressly does not exempt those vehicles from responsibility under reckless driving. And to the extent that he was parked to the right side of the driving lane, that also doesn't exempt him from responsibility because, as we noted in our brief, lawful conduct can be reckless under the circumstances.
Counsel, if I may interrupt you here, the petitioner says, sorry about that, but the petitioner says those facts are not really disputed about the amber lights and where the truck was parked. The state police did a really good reconstruction of the incident. But the ALJ has those notes in the decision that she's not going to look at the driver. She's not going to punish him any further. And the purpose of this hearing wasn't necessarily to determine whether or not Mr. Bauk was reckless, but to get to the heart of what happened during the accident. That's his position. And so the ALJ had a little bit of blinders on because she wasn't going to look at the full circumstances of what was going on County Route 8 at the time, because she was so sympathetic to the impact of this accident on the driver of the car.
So that's certainly what he's arguing.
Right.
But that's just not true for what this hearing was. It's a VTL 510.
And he says that because of that evidence in the record and in the decision, the ALJ abdicated her duty to look at this objectively, the facts.
Right, he's arguing that.
Yeah.
I just don't think that that's supported by the record here. The ALJ considered the facts, the circumstances of the night that he parked and how he parked and the weather and that his lights were obscured. I think the ALJ put down a fairly good record, and as did the administrative appeal. But the argument that, well, she didn't punish, or that DMV didn't punish Padilla just has no relevance here. It's two separate determinations.
Well, his position, I think, is she was predetermined in the outcome here, that this was predetermined and is stretching a little too far and not considering all of our arguments. And so therefore, whether or not the record supports this finding of recklessness, and he talks about reckless driving, of course, there isn't any other violation that the ALJ found here, right?
No, the ALJ found that his conduct was reckless, but that's supported by the substantial evidence in this record. It was, his tow truck was parked more than 5 feet into the roadway, as the ALJ found. It was wet, it was...
Are you saying that there's absolutely nothing wrong with the ALJ making those findings relative to his conduct, even if, and I'm not saying you agree with this, but even if the examination of the conduct of the passenger vehicle wasn't examined as closely as maybe it could have been?
Right, because Padilla's conduct it's not dispositive of whether Book was reckless in parking his car. That there was a collision is not an element of VTL 1212. It here demonstrates how reckless and how much Book unreasonably interfered with the roadway. But Book could have been found responsible for VTL 1212 if before the collision happened, a trooper pulled up and saw his tow truck there. So it's just not relevant to the determination against Book, anything about Padilla. And I will just note that the facts that he is relying on in his brief, that Padilla's head was turned, for example, is not part of the record that was before the agency. That comes from the civil trial outside of this proceeding.
Anything further?
Just on the penalty, it hardly shocks the conscience here. Book's conduct resulted in a child losing his life. And if the court has no questions, I'll rely on my brief.
Thank you, counsel.
Thank you.
Thank you, Your Honor. I think, I agree with Judge Del Conte here. The fact that this ALJ had said, I'm not even going to look at what Padilla is because he suffered enough, all right? That shows where her mind was. It does show an abdication of her job. There needs to be some sort of predicate VTL violation to get to reckless conduct. There's nothing here. The tow truck was allowed to park in the manner that it did. You are supposed to park along the side of the road as far as you can get. In this particular case, he's got the light bar. Those light bars can not only, they aren't only seen front to back. There's evidence in this record that it lit up the countryside. We also have the police, they said, well, maybe the four-ways aren't going. They know it wasn't, the four-ways weren't illuminated at the time of impact. Doesn't mean they weren't on the off phase. But they did say, scientifically, we can say that the taillights were on.
Counsel, I don't think there's any dispute about the condition of the truck, but maybe whether or not the four-ways were flashing at the time. But the fact that's undisputed is the truck was almost 5.5 feet into the driving lane, which meant that every car traveling southbound had to cross the double yellow and go into the other lane to get around your client's truck.
And they all did.
And they all did.
Except for one that had his head spun around, looking in the back seat.
Right. And in the event that other cars are passing, I mean, the ALJ's determination here in terms of the recklessness dealt with where your truck was positioned, I think, on that roadway.
The problem is that that's mere negligence. You get to recklessness for that. You are putting it in the same position as somebody that's drunk, that's up on the side of that's on a sidewalk going through a crowd of people.
But can't the ALJ find that she's, doing her investigation, taking the testimony, and she makes a finding that based on those facts, it's reckless, and she doesn't need another violation of VTL though. For 1212, I don't know that you do.
I think the court of I have not seen any precedent where there wasn't something else beyond that. Everything that the tow truck driver did in this case was legal.
Well, you're basing that partially, you're claiming that the tow truck driver is the emergency vehicle that your opponent's saying is not covered by the...
Even if he isn't, this is not a no parking zone. You can park on the side of the road. You can park on the side of, on almost any side.
On the side of the road, but not in the road.
Well,
you have to... you can be in front of the Civic Center here and just park wherever you want.
Right, but there's a certain practicality of it. The VTL says you're supposed to park as far off to the side of the road as you can. There's nothing that says my guy now has to somehow be in someone's yard. He is legally entitled to be there as a parked car. He's got his headlights on, he's got reflective tape, he's got a light bar that not only can be, even if it's blocked by a passenger vehicle.
So are you saying, so if this truck had, let's just say the first, 1/8 of the truck was in the side of the road, but the rest of the truck was extended across the road. You're saying he was in the side of the road. He was legally parked. He was fine where he was.
He was. It certainly doesn't rise.
Because the lights were on.
Well, yes, because it was under emergency operations. And
even though he could have gotten off to the side of the road completely safe, you're still saying that's fine what he did. As long as some part of his vehicle is on the shoulder or off the road, he's fine if his lights are going. Is that the argument?
I think from a tow truck standpoint, yes. But in this particular case, whether he could go, if you look at the photographs, I don't know if he could go completely onto the shoulder. I think he was over as far as he was going to go without going, into a ditch or whatever was over there. But in this particular, to get to recklessness, this prevents my client from even getting a hardship license. He can't have a license for the entire length of the suspension, even though the ALJ couldn't identify a single statute that he violated. That's supposed to be the standard. Did you violate a VTL that contributed to this to some degree? Whether there should have, this is where it shocks the conscience here. We all know that there was somebody that died in this. In my opinion, I think it was because the dad had his head spun around and couldn't turn his head around fast enough. Because we had multiple cars that saw this and went by no problem. But to get to recklessness, I think that's...
Well, that's the issue that we have to address.
I don't think that there is no such thing as negligent parking or reckless parking. It's a reckless driving. Every other time where it's been applied, where somebody has been in the road stationary, there's been other things. They've been drunk. They've gone up on a curb. There's something else here other than just being parked on the side of the road.
We'll take a look at that.
It's a 180-day suspension, and it's stayed right now, is that correct?
It is stayed right now. Actually, the status of it right now is that the lower court vacated the decision because this was an arbitrary and she didn't apply the law. And again, that's our contention. I don't think she applied the law.
Thank you.
Thank you.
Case 890, Ashley versus Upstate Emergency Medicine et al.
Glasses are up here on this podium.
Up. Counsel, did we leave your glasses up here?
I bet it did, yes.
You lost yours? You lost yours?
I got my backups, that's why. Backup.
Counsel, proceed.
Good morning, Your Honors. It's still morning. Good morning, Your Honors. May it please the court, Corey Schoonmaker on behalf of the defendants. Supreme Court erred in denying defendants' motion for summary judgment because the affirmation of Dr. Bartfield met defendants' burden and plaintiff's expert affirmations were speculative and conclusory. This is a case involving the alleged misdiagnosis of a condition called spinal epidural abscess. It is an infection that occurs on the spine, well, an abscess specifically. It presents with, as Dr. Bartfield outlined in his affirmation, back pain, headache, fever, difficulty walking or difficulty with coordination, nausea and vomiting, altered state of consciousness, weakness in the extremities, incontinence, or progressive inability to use your extremities. The only symptom that plaintiff presented with to PA Schutte was back pain. And as Dr. Bartfield explains, and perhaps may be so general that it needs to not even be expert fodder, back pain can be caused by any number of conditions.
They also knew the plaintiff was a past IV drug user, too.
Yes, so there was a statement that he used to do intravenous drugs.
And that's the tipping point, right? That's what the plaintiff's expert says?
That is one of the...
If you know that your back pain, prior IV drug use, you better look for an infection, spinal infection.
Yes, that is essentially what plaintiff's expert said. However, plaintiff's expert failed to address the opinion of Dr. Bartfield that there is a distinction between having done IV drugs at some unknown point in the past and being currently...
Just to follow up on Justice Del Conte's question,
Yes, Your Honor.
there was no diagnostic testing performed before the patient was actually removed from the hospital.
There was, there were some, it depends on what you mean by diagnostic testing, Your Honor. There was a neurological test performed, there was a grip strength test performed, both of which contradicted a diagnosis of a spinal epidural abscess because they were normal, and those are symptoms you'd expect to see for an abscess.
And unless I'm misreading the record, and again, I read a lot, so I could be, but I thought the client or the patient refused to leave because he was in so much pain. He said his pain was 10 out of 10, and he was physically removed from the hospital.
Yes, so that did occur. So what the timeline of events here, he was seen by 2 nurses, I believe there were only 2 nurses, and then PA Schutte, who did an examination, determined based on the evidence that was available to her that the most likely diagnosis was a muscle spasm. He was discharged to home, and after being discharged, he refused to leave the hospital. But PA Schutte wasn't involved in the interactions with him directly as he was refusing to leave the hospital. So one of the issues in this appeal is that plaintiff's expert points to, oh, well, he was begging to be seen, he was begging to get an x-ray, but the word begging is very important because that was not what was made known to PA Schutte.
Well, and he wouldn't let them take any vital signs.
That is correct. There's also a significant factor is that both the prior nurses before he was seen by PA Schutte and to PA Schutte himself or herself plaintiff refused to allow his vitals to be taken, so there were only certain diagnostic techniques that could be performed at that point. If he would not consent to the basic vitals being taken, certain things couldn't be done, and given the limitations presented, as Dr. Bartfield opines, the diagnosis of a muscle spasm was within the standard of care under the particular circumstances of what was before her at that time and what she was able to actually ascertain.
You cited in your brief the other case we had on earlier today, didn't you?
I may have, Your Honor. It is possible.
By Supreme Court, not our court.
In response to Dr. Bartfield's opinions with respect to P.A. Schuette's treatment, plaintiff's expert was speculative and conclusory for a number of reasons, as we outlined in our brief. I'll just emphasize a few that I think are the most significant. The first thing, and I think this is important for both P.A. Schuette and Dr. Klimek, is that this is a physician from New Jersey, which sometimes is fine, sometimes is not fine. When you are not practicing in the area that you are opining, you have to establish in the affirmation that you have the requisite knowledge to render those opinions. Now, a lot of areas of medicine have national standards of care, so if those apply, then the locality rule has kind of been abrogated to some extent by the concept that medicine is largely national.
Specifically with emergency rooms, though, right? Wasn't that in the?
Yes, he is an emergency room. I'm not referring to his specialty being incorrect. More to do with his understanding or lack thereof of PA practice and the differences between New Jersey and New York in that regard. This is most obvious when we talk in the context of Dr. Klimek and supervision, because you can tell by reviewing the regulations in New York and the regulations in New Jersey, which are different, that this expert is basing his opinions on the New Jersey standards. In New Jersey, just like New York, the physician doesn't have to be physically present during the PA's treatment, but in New Jersey, they have to be in contact with in communication with the PA while that treatment's being rendered. That is not the case in New York. In New Jersey, the regulations presume that counter-signature is going to be required for the PA's treatment and orders. In New York, it is presumed that it would not be, unless it's required by the doctor or the hospital. So from those differences, you can see that the plaintiff's expert is expecting Dr. Klimek to have been involved in this treatment when there's no obligation for a supervising physician to make themselves involved if the PA doesn't ask for their perspective on it. That is sort of more of an example when you back-relate it to P.A. Schuette, but it shows that this expert has not established a familiarity with PA practice in emergency rooms in New York and the scope of their treatment, particularly because even though in the surreply affirmation, the expert said that they had worked in emergency rooms in New York, they don't ever say that they've supervised PAs or they've interacted with PAs, which we can't really presume just from general emergency room practice. We have to take what he says at face value. The more detailed aspects of the plaintiff's expert affirmation are also speculative and conclusory. I talked earlier about specifically the failure to address the distinction between being a current IV drug user and having done something in the past as to whether that's a risk factor for an abscess. He or she also makes opinions that P.A. Schuette should have reevaluated plaintiff, but doesn't explain what should have triggered that. It's literally just a conclusion. Refers to things about, when we get to the surreply, refers to things about the certain information that P.A. Schuette would not have had, like the extended wait times or the events that happened where he was refusing to leave. All that P.A. Schuette was told about that was that he was refusing to leave and was using belligerent language. That's what the notes reflect. To some extent, I think globally, plaintiff's expert is kind of conflating the knowledge of the entire emergency department with the knowledge of P.A. Schuette and their treatment. To the extent that the nurses knew certain things, that doesn't necessarily mean that P.A. Schuette knew it, and I think plaintiff's expert is assuming that. I've sort of front-loaded Dr. Klimek's, but I think that it should also be noted that he's not vicariously liable for P.A. Schuette because he did not directly employ her. P.A. Schuette was employed by another company called MedBest, and that is clear in the law that there's no respondeat superior liability. In order to find that there is negligent supervision, there would have to be some question as to whether the negligent supervision actually caused any deficiency in the treatment, and here it's undisputed Dr. Klimek wasn't even tangentially involved in looking at this chart until after the treatment had been rendered. He could have had no effect on what was happening. Finally, with respect to the practice, UEM, it is not vicariously liable for PA Schutte because, again, it did not employ her. And the Maduba Doctrine does not apply to UEM because the Maduba Doctrine is based on the concept that an entity, such as a hospital or a nursing home, has held itself out to the public as offering certain medical services, but then, unknown to the public, has subcontracted those services. And so you hold the hospital or nursing home liable vicariously for the acts of their subcontractors when normally you wouldn't because of that apparent agency. In order to find UEM liable for PA Schutte's treatment, you would have to find that that UEM held itself out to the public as providing these services, and it did not. UEM was the subcontractor who was, unbeknownst to plaintiff, supplying a physician to supervise PAs in this ER. It's the hospital who that doctrine would be applied against, not UEM.
We'll take a look at that, counsel. You should begin to wrap up if you're not done.
That's all I have for anything else, unless the court has any questions, we'll rest on our paper.
Thank you, counsel.
I'll be brief, Your Honor. The respondent went to the hospital because he wasn't, the emergency room, because he wasn't feeling good. He had so much pain that the blood pressure cuff was causing him excruciating pain when they tried to put it on his arm. And it's a clear case of no diagnostic testing be performed by this individual who was in acute distress, who was then, because he had previously used drugs, was thought by the PA that he was there just to get more drugs. And
They did ask for more drugs.
Huh?
You did ask for more drugs.
Yes, because the drugs, what they gave him was not sufficient to obviate his pain.
Yes, specifically for the morphine.
Yeah.
The good stuff, right?
The good stuff.
And, but he needed a workup and diagnostic testing before he was thrown out of the place. And 3 days later, he came back with the spinal epidural abscess, which relates back to the area that he was complaining about in his back that he...
Mr. Strano, are you arguing that even if he appeared at the hospital and one of his motivations, of course he's in pain, he's telling everybody he's 10 out of 10, if one of the motivations is to seek some type of drug relief
for his pain,
even if the hospital were to say you think he's here just to get some drugs, that doesn't obviate their responsibility to this patient in terms of the number of tests they have to run to determine where his condition is. Is that right?
Yes, because that's what you do before you throw somebody out. You test them to make sure there's no problem. And in addition, I think there was an indication that there was an extended wait for treatment while reporting that severe pain. And I think before he left, he said he didn't want to leave because he said, "What's wrong with me?" I think that was his direct quote. And as far as the doctor is concerned, the doctor didn't look at things till 4 days later. And there was no determination why there was a problem with the blood pressure cuff. And everything he's talking about with the plaintiff's expert, I think, goes to the weight of that report rather than the credibility and rather than admissibility. I'm sorry. As the trial court indicated, it's a matter of battle of the experts again. and we submit that the order should be affirmed. Thank you again for coming to Syracuse.
Thank you, Mr. Trino.
I'm not going to be able to get out.